The Honorable Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Thank you and good morning to everyone. Thanks for joining us for this Zoom argument. We have 4 cases to be heard this morning. I would anticipate that we can go through them without a break, but let's see how things go. We'll start with United States versus Joel Smith, number 245088, and counsel, you may proceed.
Good morning, Your Honors. Thank you. Can Your Honors hear me okay?
Yes.
Thanks. I'm Leah Yaffe with the Federal Public Defender's Office for Mr. Joel Smith. And the issue in this case is that the district court erred at sentencing when it determined that there was no sufficiently analogous guideline for Mr. Smith's conviction for Oklahoma child abuse by injury. And instead, pursuant to guideline 2X5.1, the district court should have analogized that conviction to the federal assault guidelines. So the law here is that when there's a crime, whether it's a state assimilated crime or an unassigned federal crime that doesn't have a specific offense guideline in Appendix A, courts need to first identify the universe of plausibly analogous guidelines for the crime of conviction. And then if there's more than one, choose the best one. And so this case, we're at step 1, and it's a really low bar to clear. And we know that from the commentary of the guideline 2X5.1, which says most of the time, the guidelines are going to cover the type of conduct that's in an unassigned crime. We know that from this court, which has repeatedly expressed how low the bar is, including in Rakes, when it said what we're looking for is something that's within the ballpark of the crime of conviction. We're just looking for a general umbrella that the state crime here can fit under. And the reason it's a low bar makes a lot of sense because the goal is to just get as many cases as possible into the framework of the federal guidelines.
So do we have, can you direct us to whether we're looking at 2A2.2 or 2A2.3? You had a footnote in your opening brief that sort of suggested, it's either both. I mean, it seems like your argument is directed at 2A2.2 on appeal, and that's it, right?
I think this case ends up in 2A2.2, the aggravated assault guideline. The reason 2A2.3 is mentioned is just that because the district court found that there was no sufficiently analogous guideline at all, it stopped at step 1. And so going through the process in order in any case like this, both assault and aggravated assault are going to be within the universe of possibilities. I think it's pretty clear in this case that once everything goes back and is completed, the full analysis, we're in aggravated assault, and we're not intending to suggest that this case is the appropriate one for the regular assault guideline. It's just informative at this step 1 process.
The district court cited United States against Clark. If an argument failed under Clark for child neglect, why shouldn't it similarly fail for child abuse?
I actually think Clark is a great case for us here because the specific thing that that this court thought was not analogous enough between child neglect and the federal assault guidelines was that child neglect at heart is a crime of omission. You don't need an affirmative assaultive act. Here, that is what the difference is with child abuse by injury and child neglect in Oklahoma. There's 2 different crimes. This one is the one where you need an affirmative assaultive act. That was something that was significant for this court in Clark, I think understandably for the child neglect conviction. But here we have exactly what Clark said that you would need from the Oklahoma state crime in order to be analogous to the federal assault guidelines. So really it's that both child abuse by injury and the various federal assault crimes require an affirmative assaultive act that risks and typically results in some degree of bodily injury. And I point out that I don't understand the government to really challenge that the basic acts or conduct covered by child abuse by injury is analogous to federal assault, or even that most of the time we're talking about something that results in bodily injury. And that's really what we need to clear this low bar. What I understand the two main differences the government has raised to be, which I don't see as differences, but I'll go through them both, are mental state and whether sometimes you can have mental injury instead of just physical injury. So starting with the first one, mental state, child abuse by injury has what's effectively a knowingly general intent mental state. There are some federal assault crimes that have a lower culpability mental state, recklessness, or even lower. There are also federal assault crimes that require something even higher than knowingly. So we have specific intent crimes that are covered by the aggravated assault guideline. So when we're asking, is this guideline, does it capture within its umbrella the mental state, the severity of culpability from a mental state perspective that Oklahoma child abuse by injury does? The answer is yes, because knowingly falls within the range of mental states that are covered by this guideline. And we know that this test at step one is to loosely compare the elements of child abuse by injury to the elements of all the federal assault offenses that are within a given guideline. And so
is it your position that that there is no mens rea gap because the mental state doesn't need to match? You're just, if I understand your argument, the match is that there's intentionality of some kind.
Yes, so I think that's correct. I'll restate it just to be clear. The argument is that there's the mental state that's required in Oklahoma is captured within the guideline. We don't need to point to one specific type of federal assault that has every single element that child abuse by injury does. If that were the case, child abuse by injury would have a guideline assigned to it. What we need to show is that there's a guideline that broadly encompasses the punishment rules for this degree of culpability. And I'm not sure that a minor difference in mental state, I don't think that would even render something not sufficiently analogous for purposes of step one. But here, I don't even think it's a difference because we know this type of culpable mental state is in fact covered by the assault guidelines, and specifically the aggravated assault guideline. For the second difference that the government raises, the government points out that in the Oklahoma jury instructions defining torture, which is one of the means of child abuse by injury, one means of committing torture is potentially extreme mental cruelty, so not requiring bodily injury. I think as a threshold point, this is a little bit of an unsettled question in Oklahoma. The jury instructions say that and then reference also a case that has held that there is no mental injury in a child abuse by injury statute in Oklahoma. But assuming the government is correct and that some of the time you're looking at just mental injury, that's also true for the federal assault, for federal assault statutes, right? So there's simple assault, there's ways of committing an assault that's an attempted battery and not a true battery. Again, this isn't a difference. And even if it were possible that there's a little bit of difference between the type of mental injury or whatever it is in Oklahoma and federal assaults, what we're talking about is this roughly the same? Is it roughly comparable enough that we can use the federal guidelines in this case, as opposed to have no guideline at all and just ask a district court within the statutory range of 0 to life to do their best and to start from scratch? And I don't think either of these differences that are in the answer brief are the types of things that would say, you know what, unfortunately, this is a case where we do not have the benefit of the federal guidelines.
Let me ask you, let me turn this around a little bit and just ask you a question about it. If this were a charging decision we were talking about, and the only injury we could prove was a mental injury, and would we be able to proceed under the federal assault statute?
I think that would probably fall under at least simple assault. So you'd have an attempted battery, or another version of that is putting somebody in reasonable apprehension of immediate bodily harm.
Do you have a case on that?
I actually think that I need to double check, but I believe that the Harris case cited in the reply brief is an example of a simple assault case where somebody drew a dangerous weapon on someone else, but there wasn't actually physical injury. And if I'm giving you the wrong case name, I'll follow up, but I believe it's the Harris case in the reply brief. But I don't think there's a real question that some of the time an assault is an attempted battery instead of an actual battery. We know that from Clark itself, where it says normally we're talking about something that results in bodily injury, but obviously there's simple assault, and what we need is an attempted battery, a battery, or placing somebody in reasonable apprehension of immediate bodily harm. I really don't see that as distinguishable from child abuse by injury, where you're looking at what is effectively, the OCCA has told us, a battery statute for children, and may or may not have at least a component of a mental injury that results from a true assault as opposed to an assault and battery. If this court doesn't have questions on error at this point, I might quickly turn.
Well, could I just, before we leave this, could I just quickly ask you, given that you're not challenging the 180-month sentence for the child neglect conviction, why isn't any error on the abuse sentence harmless?
A couple of reasons, Your Honor. So I'll just walk through the steps, if that's okay. The first is we know many times over from this court and the Supreme Court that guidelines ranges have an anchoring effect on a sentence, and that if you skew the starting point, you have reasonably possibly skewed the end result. And so there's at least, we know that the government can't meet its harmless error burden here for child abuse. So then you ask, does that extend over to the child neglect conviction or sentence? And it's reasonable to believe that that downward anchoring effect on the child abuse sentence would also have at least some effect on the child neglect sentence in this specific case, because it's very intertwined conduct. It's the same time period, it's the same course of events, it's the same victim. The district court has indicated that it sees the two crimes as comparable severity here because it awarded them the same sentence. And there's not some other anchoring hold on the child neglect that might undermine those inferences in this case. So for instance, there's not a mandatory minimum that applies to the child neglect where we know it's not moving. So really the only new information that the district court would have on remand is this offense that you think is comparable to child neglect has a significantly lower guidelines range than the 180-month sentence that was originally awarded. If these two crimes are comparable, it's at least a reasonable inference that there's going to be some downward movement on remand. And this is ultimately something that the government's not going to be able to prove otherwise for harmlessness purposes.
Do you have a case that you can point us to that you think meaningfully sets out the relevant data points that our circuit looks at for whether this sort of sentencing package doctrine argument proves availing? You're sort of walking us through what kind of things we should look to determine why it's reasonable here to conclude the government wouldn't meet their burden. And I'm wondering if there's a specific case that you think our circuit has that articulates those data points.
Sure. A couple things come to mind. So just the first part of that steps that I just went through, we have Sabione Umana, we have Melina Martinez cases explaining the downward anchoring effect of a guideline and how important it is. And then with the sentencing package doctrine idea, I think in the opening brief we cite to Cattrall, and there was actually an 11C1C plea agreement to a specific sentence. And even in that case, when one sentence had to be sent back and vacated, this court recognized, like, while I understand that the parties agreed to the ultimate bottom line, we understand a district court to see the overall punishment as one punishment package. And if a piece of that is flawed, then we have them do it by scratch. A district court starts over. We don't assume that they start from the end point of the flawed sentence. We assume that they do a complete de novo resentencing. And when that happens, the downward anchoring effect that we know about the guidelines, the interrelationship between these counts, the fact that the district court here, in fact, gave an overall sentence before explaining how it would be split up, all of those things lead us to the conclusion that it's at least likely that the district court is going to go a little bit down from 180 months on remand.
So do you see this playing out as we issue a decision that vacates both sentences and sends it back for resentencing?
I think typically when there's a vacating of one sentence, you go back for a de novo resentencing. So yes, that's I think the standard approach for when there's a sentencing error is to remand for a complete resentencing. In this case, we would ask, the district court would need to determine the exact.
So direct me to some authority where there's only been a sentencing error claimed and not an attack on an underlying conviction where one sentence was unchallenged and we vacated them both and sent it back to start fresh.
I think Catrol is a good example of that, just to use one that's already in the briefing, where there wasn't a challenge to, I think there was maybe 2 or 3 other counts, but there was to the aggravated identity theft sentence in that case. And because there was a flaw in that sentence, I think this court expressly directed the district court to just start again on remand. I see that I'm out of time. So unless the court has further questions, we'd ask for a remand for resentencing.
All right. Thank you, counsel. Ms. Olam? You need to unmute.
So sorry, Lena Alam for the United States. I would like to start by clarifying a couple of points that Ms. Yaffe characterized about our position, particularly about what kind of conduct is required to violate the Oklahoma child abuse statute. When we talk about child abuse by injury, both the mens rea and the conduct are different in kind from a typical federal assault. First, I think I heard Ms. Yaffe say that the mens rea for child abuse by injury was a standard criminal intent, knowingly or intentionally. Rather, 843.5 has a mens rea of willfully or maliciously. Second, to the extent that our brief talks about the fact that the Oklahoma jury instructions make clear that torture can be achieved by extreme mental cruelty, that doesn't go to the extent of injury in a child abuse case. That goes to the type of conduct that can constitute torturing a child. And this case, like its companion, illustrates the gulf between the range of conduct and the harms covered by the Oklahoma child abuse statute and the federal assault regime, right? Here, and the facts of this case, although they're not material to the assessment of whether the guideline is sufficiently analogous, certainly illustrate why the breadth of conduct that is covered by the Oklahoma child abuse statute goes far beyond what's contemplated by the federal assault statutes. Just for example, the trial testimony describes in some detail the conduct that Joel Smith engaged in that would not constitute a federal assault, but that did constitute torturing MV. For instance, forcing her to wear a diaper when she was 9 years old, all night long, all day, working outside. None of these things involved an attempted battery or physical contact. Was there other conduct that did qualify as an assault? Absolutely. When he beat her with a belt, that was an assault. But so much of this conduct goes beyond that and still constitutes child abuse under the Oklahoma statute, that both under the guidelines and, as we'll discuss in the next case, under Lewis, these are very different crimes.
But counsel, could you help me understand why we should be engaging in this sort of factual inquiry when we've said it's an elements-based inquiry? And so I'm not quite sure how to situate what you just told us into what our law requires that we review.
No, precisely. And I think, as I just said, this is an elements-based inquiry. This is just an illustration of the breadth of the Oklahoma statute. But when we look at the elements, we look at the jury instructions promulgated by the Oklahoma Court of Criminal Appeals, and those instructions define torture as including extreme mental cruelty. And the conduct in this case illustrates really how that can provide a way to violate 843.5A without committing an assault. And that's why the district court did not err in concluding there was no sufficiently analogous guideline, that neither 2A2.3 nor 2A2.2 was sufficiently analogous. It's not clear to me that the court considered 2A2.3. I think the court was just accepting that Clark said there was no sufficiently analogous guideline for child neglect and extrapolating that to child abuse. But and that brings us to another point. And I think Ms. Yaffe talked a lot about our burden of showing harmlessness. In her brief, she explains that the concurrent sentencing doctrine is a discretionary doctrine, but and suggests that it's been regarded with disfavor. But the Williams case that suggests that the concurrent sentencing doctrine has been regarded with disfavor cites a 1982 case from this court, Montoya. And what Montoya recognizes is that the reason the concurrent sentencing doctrine is sometimes regarded with disfavor is because when a defendant challenges one of the convictions, there are collateral adverse consequences of a conviction, and so the court should address the validity of a conviction. In 1987, the Supreme Court agreed, and in Ray versus United States, made clear that the concurrent sentencing doctrine does not apply under those circumstances. But this case in Harris in 2012, not the same Harris case that Ms. Yaffe was talking about, but in Harris, applied the concurrent sentencing doctrine and explained the distinction that in Ray and Montoya for that matter, and I think in Williams, the 2022 case, all of those cases involved circumstances under which there were adverse sentencing or collateral consequences, and the defendant was challenging the conviction as to certain counts. Or as in Williams, where the changing the drug quantity calculation as to the drug count also changed the potential sentence on the gun count because of a cross-reference. Those are cases in which applying the concurrent sentencing doctrine would not be appropriate. Here, however, Mr. Smith has conceded that the district court did not err in finding there was no sufficiently analogous guideline to Oklahoma child neglect. That 120-month sentence should stand. And if you look at the facts of sentencing here, the government asked for a 240-month sentence, the defendant asked for a 60-month sentence, and the district court imposed a 120-month sentence on both counts. And I respectfully disagree with Ms. Yaffe that the fact that the court gave the same sentence on both of those counts after finding no sufficiently analogous guideline suggests that the court would be inclined to impose a lower sentence on both rounds if this were remanded.
Well, counsel, just to make sure we're understanding your argument,
Yes.
Do you need the concurrent sentencing doctrine to succeed on this issue?
I should not, because I don't think that the district court erred in finding that the federal assault guideline was.
Well, I understand that part, but do you need it on the harmless error part?
There are actually two different ways that I could win on harmless error. First is if this court just looks at it and says, this is not a court, given the statements that it made and the decision that it made at sentencing, and the fact that the defendant has conceded that the 120-month sentence, the no sufficiently analogous guideline finding was correct as to child neglect, the court could just decline to review this under the concurrent sentencing doctrine. However, it could also look at the record and conclude, particularly based on the egregious facts of this case, and the circumstances of the similar case in Walker, where the government conceded that 2A 2.2 was sufficiently analogous, but the court, or the district court, explained that it was peculiar, that the guideline was peculiarly inadequate to address the harms of child abuse. And thus this court could conclude that even if it did not exercise its discretion to apply the concurrent sentencing doctrine, that the error here was harmless, because even if this were to go back, the district court could apply whatever guideline and conclude and vary upward to apply the same sentence for child abuse as for child neglect. And
Okay.
that's
Could I just ask you, is there anything else that the court said at the sentencing proceeding that would give us reason to think it's reasonably probable that the court would still impose a 120-month sentence?
I don't think the court said a lot about its reasons beyond that finding. But I'm sorry, I don't have that transcript before me. But I note that my brief does not cite a lot of language suggesting that the court said, as courts sometimes do, that I would impose the same sentence regardless of the finding. So we don't have that. But given the fact that an assault conviction and sentence in the range that's discussed in the briefs would have applied if Joel Smith beat MV with a belt one time. And here we have a situation where the testimony establishes that these children were beaten daily, that he locked her into a pack and play every night, made her work in the hot sun from the ages of 5 to 9 for 4 years. I do not think it is even colorable that on remand this court, that the district court would impose a sentence lower than 120 months as to the child neglect. This is a child
Counsel, could you address Cottrell, the Cottrell case? The appellant relied on that, and that seems to suggest that in the normal course, when we are mindful of the sentencing package doctrine, that we would remand in a way that the district court would be free to resentence on all counts. So could you address that, please?
Yes, and my answer to that is simply yes. I am often here arguing for application of the sentencing package doctrine, right? That one count, that a significant error in one count would result in at least a possibility of a lower sentence as to the other counts. I just think that both the facts here and the fact that the district court had the full range, right? This wasn't a case where the court felt constrained by any guideline. The defendant asked for a 60-month sentence, and that was a sentence that the judge could have given as well. There was not a statutory minimum. There was nothing really that led this court, other than the 3553A factors, that led this court to the 120-month sentence it imposed, or sorry, I think that's right. The 120-month sentence it imposed, as opposed to the 240 the government asked for or the 60 that the defendant asked for. This is a situation where, unlike those sentencing package doctrine cases, there's no reason to believe that the sentence the district court chose was anchored by anything. And so moving that range for one of the counts doesn't suggest that the district court would change the sentence as to the other counts.
Thank you. That's very helpful. I think I better understand your argument. I think that, and please tell me if I've got it right, I think the government is not challenging the standard here, right? That the sentencing package doctrine doesn't apply. You're not suggesting it only applies when a conviction has been vacated. It squarely applies to the situation here. It's just that the facts here don't result in a position that would support the appellant, right? You're not quibbling with that first principle, right?
I'm not sure that That's, I think, maybe a stronger statement of our position. Where the defendant hasn't challenged their conviction on the first count and hasn't challenged the same decision that was made by the district court as to the second count, our position is that the lack of likelihood that or the lack of relationship between those two sentences, where there's no guidelines change as to the second count, or no guideline, and particularly here, where the district court didn't. This is not a case like Cattrall where the sentencing guidelines were wrongly calculated, right? Where the district court was applying the wrong guidelines range and imposed a sentence based on the wrong range, and needs an opportunity to correct it, because the wrong range in those kinds of cases is what directs the district court's first sentencing determination. Here, the district court had ultimate discretion as to the entire range of punishments and chose 120 months. And for that reason, those sentencing package doctrine cases that focus on where the court got the range wrong and the new range would suggest that it should reconsider the entire sentence. Those cases don't really apply in this circumstance, partially because of the facts, but more because the facts here are that the district court had before it the entire range of punishment. Does that answer your question?
It does.
Counsel, could you address the anchor effect argument? Oh, and before you do, I think I got us off track on the sentence. I think it's 180 months.
Thank you.
Yeah.
Yes, I definitely misspoke a couple of times there. I think Ms. Yaffe's correct about the anchoring effect of a guideline sentence, and it's really the crux of the sentencing package doctrine as well. But here, because the counts, although based on related conduct, reflect the seriousness of the offenses, the child abuse conviction is for conduct at least as serious, if not more serious, than the child neglect conduct. And therefore, we don't believe that on remand, the district court would change its sentence at all. And for that reason, we would ask this court to affirm.
Thank you. I think we're out of time. Thanks to both of you. You both packed in a lot of arguments there. And so I think we used the time efficiently. At this point, we'll consider this case submitted. Ms. Yaffe, I think that's it for you today, correct? Do you have another argument? If not, you may be excused, and Ms. Alam will be seeing you in the next case.
Thank you, Your Honors.
All right, I will go ahead and call the next case as counsel's getting settled in. It is United States versus Amanda Smith, number 245096. Mr. Gifford, you may proceed.
Thank you, Your Honor. I will be requesting to reserve 2 minutes of time to respond to the government's argument as well. I've raised 4 issues before the court, and the fourth one having 2 subparts. The first one is that the district court erred when it did not grant a new trial based off this circuit's unpublished ruling in United States v. Shell, in which that court found that the use of assimilating the Oklahoma statute for the purposes of child abuse was improper. This decision did not come out until shortly after my client, Miss Amanda Smith, was sentenced in this matter.
Counsel, was that argument available to her before the trial in this case? Couldn't she have made that same argument then?
Yeah, yes, Your Honor. If I guess if I had analyzed it and thought of raising that issue, and again, I didn't foresee that issue because number one, it's been a common practice the way we'd always practiced, been charged that way. It's the way the government's always charged it. When the new issue came up where somebody raised it around the same time and the court issued it, it seems that it would be fair that Miss Smith should be able to benefit from it. Again, this is within the 14 days of her conviction becoming final at that time, and with 10 days afterwards, we raised the issue of the law of the 10th Circuit. And again, when you look at it, would the government be prejudiced in it? Now, there's several things. One, is there neglect on my part? Yes, I can make arguments on areas of the law that have not changed yet, but have to be able to foresee them. So when someone changes the law, then I, as her attorney, have to have a duty to raise that obligation to the court, which I did under the Shell case. In this case, by that change in the law, which would have changed the
counsel. I mean, we all understand that Shell's unpublished, so it isn't quite a change in the law, is it?
Well, I think it has changed the charging decisions by the United States government. The 10th Circuit has expressed, at least in an unpublished decision, that the use of the assimilation of the child abuse statute, as happened here, would not be appropriate to use.
Yeah, but it wouldn't. The case isn't binding on us, correct?
Yes, Your Honor.
And it wouldn't have been binding on the district court either.
Correct. I mean, but it would be obviously a wise argument for the district court to consider the law as the 10th Circuit, even though it's an unpublished decision by another panel, to at least take it into consideration as to how the 10th Circuit may view the use of that statute. Your Honor, moving on to the second issue, and it's easier to discuss than it was actually to brief it, is the use of whether or not the federal government now has jurisdiction over non-natives who commit crime in Indian country after the U.S. Supreme Court's decision in Castro Huerta. Castro Huerta was about states' rights and the state's ability to prosecute crimes committed by non-Indians in Indian country within the state's borders. And that's what Castro Huerta was about. What Castro Huerta did not analyze, discuss, or even mention at all is the federal government has jurisdiction that's limited. And Congress wrote a statute at Title 18, Section 1152, in which they used the language of within the sole and exclusive jurisdiction of the United States. Now, there's general laws of the United States, such as, bank robbery is a federal crime. It doesn't matter where it happens. The federal government can prosecute it. Drug trafficking as well. You don't need 18 U.S.C. 1152 to prosecute those federal crimes. Those federal crimes are applicable everywhere. In 1152, it doesn't matter. Those are general federal crimes. Here, it talks about that crimes that are within the sole and exclusive jurisdiction of the United States. And with that being said, once Castro Huerta gave the state of Oklahoma concurrent jurisdiction, thinking about the state's rights, then it took away the federal government's rights to prosecute these cases. Federal courts are courts of limited jurisdiction. When Congress writes a statute, it's presumed that they know what they're saying when they wrote it.
Could I just stop you there? Could you say that again about Castro Huerta taking away the federal courts' jurisdiction? Is that what?
Yes.
Could you just say that again? I'm not sure I followed your statement.
So Castro Huerta was about the state's right to prosecute non-natives in Indian country. And they gave the state that right. And that was the first time since 1892, I believe, that they had that ability to do that. With Castro Huerta given that concurrent jurisdiction to the state, well, now the federal government, when it prosecutes these crimes under 1152 discusses or states that these crimes have to be within the sole and exclusive jurisdiction of the United States. So now that Oklahoma has jurisdiction, the state has jurisdiction, the federal government no longer has something that's within the sole and exclusive jurisdiction. It's now shared. So unintentionally, when they gave the state of Oklahoma concurrent jurisdiction, the federal government, being courts of limited jurisdiction, as guided under 1152, that has to be under the sole exclusive jurisdiction. The federal courts lost jurisdiction over non-natives committing crimes against natives in Indian country.
All right. So if I'm understanding what you just said, does that mean no more prosecutions in federal court under 1152?
Until Congress goes back and amends their own statute, because again, that's probably a yes or no question. I'm sorry. Yeah,
you can
yes, Your Honor.
explain it, but so if the U.S. Attorney's Office has a case arising in Indian country, the the defendant is non-Indian, the victim is Indian, they can't charge that in federal court after Castro Huerta. That's how you're reading that case.
Yes, Your Honor.
Okay.
Yeah,
although the Supreme Court never really said that, did they?
No, they never did, and it was not before them. And in fact, I even went back and read the entire argument transcript of Castro Huerta. And again, in the final opinion, they used the language that the federal and state governments will have concurrent jurisdiction. But what it didn't do is it didn't address the language of within the sole and exclusive jurisdiction of the United States.
Okay,
Nowhere,
well, that's a rather dramatic contraction of federal court jurisdiction. Correct?
Absolutely. I absolutely agree.
Has any court accepted that argument? This is a novel argument.
Your Honor, to my knowledge, that this has never been raised. No one has ever brought this up. I've raised it in, I guess, 2 district court cases. And
how did that go?
Oh, it just said, usually just a one line. Castro Huerta says the federal and state government shall have concurrent jurisdiction. But nowhere, it's never addressed. What about this language about the federal government for these types of cases can do these cases within the sole and exclusive jurisdiction of the United States? And if we're adopting, state law, and I do discuss I do an analysis in my brief talking about the Assimilated Crimes Act and how this court's handled that and how it interprets federal enclaves. But really, it just kind of goes back to the very simple question of, where in the law do we have within the sole and exclusive jurisdiction of the United States for under 1152? As of now, there's not a single crime that is now within the sole and exclusive jurisdiction of the United States. It now all belongs to the state and the federal government. And so if the federal government wants to, unless the federal government wants to prosecute, if it's a bank robbery, yes, they'll always have jurisdiction. Child pornography, yes, those laws are already written. Those are federal statutes that apply everywhere. But except for anything outside of that, 1152, they're going to be limited to those crimes that are going to be within the sole and exclusive jurisdiction.
Okay. Let me just ask you, it seems, though, that this argument goes to your client's conviction under 1152, right? Yes, and this is a different argument than your argument about the aiding and abetting, because the aiding and abetting against her was for the offense charged against Joel Smith under 1153. So they're really separate arguments, correct?
Yes, they're separate. And
okay. And as to the aiding and abetting, what I wanted to ask you about that is, under your view, and we're leaving aside your 1152 argument for now.
Yes, sir.
May a non-Indian ever be charged for aiding and abetting an Indian defendant in an 1153 prosecution? Is that ever possible? Are you saying that can never happen?
It cannot, because they simply under 1153, there's no jurisdiction for a non-Indian to be prosecuted under 1153.
Let me put the question more generally. For a defendant to be convicted of an aiding and abetting offense, does the prosecution have to prove each and every element of that offense against that defendant, obviously the government would have to prove every element against the primary defendant, but does the government have to prove every element of the offense against the aiding and abetting defendant, assuming that there is proof of aiding and abetting? I don't know if that was clear at all, but you tell me if you understood my question.
I think I do, Your Honor. I think if there's arguing that that Mrs. Smith is guilty by aiding and abetting her husband, they have to prove every element of her husband's case against her, as far as that he's native, that he committed these offenses, as well as proving that she aided and abetted.
Okay, maybe another way of putting it, do they have to prove that she is an Indian to aid and abet the 1153 charge against him?
Oh, yes, that's the only way they would be able to have jurisdictions, if they show that.
Okay, so now I'm looking for your best case for that.
Yes, Your Honor, and I want to point out just one analogy. If I aided and abetted a service member on active duty in a crime, and they get court-martialed, the United States, the Uniform Code of Military Justice has no jurisdiction over a civilian in a military court-martial. So if I aided and abetted that person, I can't be court-martialed because there's no jurisdiction over me as a non-active duty member. They can allege that somebody aided and abetted the service member, but they can't never prosecute me in a military courtroom because there's no jurisdiction over me. And that's the exact analogy on that. As far as my case law on the aiding and abetting, again, I have to look out of circuit on that. And
I don't want to take up too much of your time if it's not at your fingertips. I take it there's something in your brief.
There is, Your Honor, at page 15
Okay.
of my brief, I cite to United States v. Graham. It's a 2009 Eighth Circuit case at 572 F. 3rd 954, and they discussed this exact same scenario. It is also discussed in the Seventh Circuit, also in another Eighth Circuit case of United States v. Norquay, NORQUA 905 F. 2nd 1157, and that's Penn site 1159 through 63, and 1998 Circuit case. And in that case also cites to a Seventh Circuit case from 1984, United States v. Torres 733 F. 2nd 449, found at 453 note 1. And again, that's I discussed that and cite to those at page 15 of my brief at document 41.
Can I ask you a question about this whole issue? So the government's taken the position that because the special verdict form found your client guilty as a principal, that this issue is just a non-issue, basically. And as I read your reply brief, you didn't really grapple with the special verdict form idea. And it almost read to me that this argument sort of depends on what we do with your argument in your reply. That was sort of that this argument's depending on what we do with your section two of your brief argument.
Yes, Your Honor. Basically, the verdict form was very straight to the point, but because they charged aiding and abetting, there was no special verdict to say she's guilty because by aiding and abetting her husband in count 1 versus he was guilty of this crime because he aided and abetted her under her statute. So I do fall under that as well. Your Honors, I see that I'm out of time, and while I asked for the reserve time, I'll forego that. There's one more issue. If I just, with the court's permission, if I can have a brief 30 seconds to address that last issue before the court in regards to victim impact statements.
All right, we'll do, but a brief 30 seconds.
Yes, sir.
Or a real 30 seconds.
Yes.
Okay.
My brief discusses the victim impact statements. Why that's important is it was given to me the night before. I did not have the opportunity to respond to them, prepare for them. I didn't have transcripts from trial to even contradict them. And I was ineffective in being able to address and contradict those. For example, at trial, the victim impact statement by Officer or Deputy Burnett, she talks about certain things like this injury was hot to touch. That's at page 564. In the transcript at page 715, there's no mention of touching anything. There was other issues in which throughout the transcript, I could have contradicted each of these victim impact statements from their prior testimony. There was new information given in these victim impact statements that did not ever come out of trial, was never listed anywhere else, and given it to me the night before. And I did properly object. I filed an objection. I tried to object to the PSR writer, and I was told,
Counsel, I'm going to interrupt your 30 seconds, but very quickly. Your point is well taken. My concern is that the district court said ultimately didn't rely on any of that. And so how should we be thinking about that, even notwithstanding the fact that you may not have had a meaningful amount of time to rebut it?
It was not excluded. While the court did say that, there should have been at least some ruling about that. It was turned over late. Should have been provided with the PSR so that could be a proper response to it. And even though the court says I'm not going to consider it, the court never said I'm excluding it or I'm granting your motion to it. And I asked for a continuance to reset the sentencing just so that I could address those, and that was denied. With that being said, thank you for the extra 30 seconds, Your Honors.
Thank you, counsel. Ms. Alam?
Your Honors, Lena Alam for the United States. I'd like to start by talking about aiding and abetting. The Standifer case from the Third Circuit, cited in my brief from 1979, makes clear why Section 2 allows prosecution of a non-Indian defendant who aids and abets an Indian who is who has violated the Major Crimes Act. Specifically, Standifer explains that in 1951, when Congress amended Section 2 from someone who aids and abets is a principal to someone who aids and abets is punishable as a principal, Congress explained their reasons for doing that and said, this section is intended to clarify and make certain the intent to punish aiders and abettors, regardless of the fact that they may be incapable of committing the specific violation which they are charged to have aided and abetted. Not only did the Third Circuit apply that to uphold the conviction of someone who aided and abetted an IRS employee, in that case, the IRS employee was acquitted. And nonetheless, the Supreme Court addressed that issue and affirmed, holding that not recognizing implicitly that Section 2 allows a charge or a conviction against an aider and abettor who may not be charged under the statute, but that conviction may stand even when the person to whom the statute applies directly, the principal, is acquitted. So because the Supreme Court has recognized that Section 2 allows conviction of people who can't be charged under the statute, I think Graham in the Eighth Circuit is wrongly decided. And my brief discusses, I think at some length, why Graham came to this erroneous conclusion. Although Graham cites Standifer, it just holds that based on the Eighth Circuit's decision in Norquay, that an aider and abettor cannot be charged with aiding and abetting a crime under the Major Crimes Act. But Norquay doesn't hold that. Norquay, in dicta, mentions that the Indian defendant in Norquay, that his co-conspirator, who was prosecuted in federal court, or in state court rather, could not have been prosecuted in state court. That wasn't the holding in Norquay, it was pure dicta. But Graham took that and ran with it without addressing the specific congressional purpose between changing the language in Section 2 from is a principal to is punishable as a principal.
So what is the federal jurisdictional hook into the defendant in this case on this count?
It is, well, on, I guess it depends which count. as to counts 3 and 4, it's 1152.
Yeah, fair enough.
Right. But as to, and for all the reasons stated in my brief, this defendant, Ms. Smith, was not convicted on counts 1 or 2. This is just a question of whether she could have been charged and convicted as an aider and abetter to counts 1 and 2. But the facts in the verdict form here make clear that that did not occur, which is why
I get that, but I'm still, you know, it seems to me that I get the whole idea of Congress was trying to sweep people into this as aiders and abettors who were incapable of committing the crime themselves. But, you know, we have other competing interests here of somebody who we generally wouldn't even be able to bring into federal court on this, you know, otherwise.
Well, and again, obviously here we would for other reasons, but as to counts 1 and 2,
right.
The jurisdiction, the federal court's jurisdiction arises because the crime took place on Indian country and here had an Indian victim. So that's the federal interest. And it was, the crime itself was committed by a principal who was Indian. And that's where the source of that federal jurisdiction occurs. And for that,
almost sounds to me like you're arguing that his Indian status can be imputed to her as an aider and abetter.
I think his ability to be charged under a given statute can be imputed to her as an aider and abetter. And I think that's precisely what Congress intended in clarifying Section 2.
Okay, fair enough. I have another question about this. And that has to do with your argument that she was convicted under counts 3 and 4 as evidenced by the special verdict form. I mean, I'm not sure I got an answer to my question from your colleague, but I was looking at the reply brief and he doesn't seem to grapple with that position that you took. Can you opine on that?
Sure. I think, as Mr. Gifford, I think, recognizes, he has to win on his Castro Huerta argument to avoid my response on his aiding and abetting argument.
Okay.
And let me just very briefly address the Castro Huerta argument. I think, with all due respect, I think Mr. Gifford has misread Castro Huerta. It explicitly explains that, quote, the phrase sole and exclusive jurisdiction in the General Crimes Act is, quote, only used in the description of the laws which are extended, end quote, to Indian country, not to, quote, the jurisdiction extended over the Indian country. So it's not, the Supreme Court precisely recognized in Castro Huerta that when the phrase sole and exclusive jurisdiction is used in the General Crimes Act, it is extending the jurisdiction over federal enclaves, places within the sole and exclusive jurisdiction of the United States, to the Indian country, not that Indian country must be in the sole and exclusive jurisdiction of the federal courts. And that's, I think, the crux of Castro Huerta. Moving back to the first issue in counsel's brief, I'm not going to address the untimeliness. I think that's fully briefed here, but my principal argument is that Shell was wrongly decided. And we touched on this a little bit in talking about Ms. Smith's co-defendant, but the scope of the Oklahoma child abuse statute and the scope of the federal assault statutes. Shell collapses the Lewis test into one element by holding that if the defendant's conduct is punishable by any enactment of Congress, then the state statute may not be assimilated. That's just not what Lewis stands for. And looking at this, Ms. Smith's conduct makes clear that her offense cannot be assimilated under either Lewis prong. First, for the reasons we discussed, some of the abusive conduct in this case, the forcing the child to wear a diaper until injured, right? Maliciously torturing a child and causing injury is not assaultive conduct. It doesn't require an affirmative touching or and so for those reasons, the first prong of Lewis is not met by Ms. Smith's conduct. So it should be, that could be the end of the inquiry. But the more important argument here, and honestly in Shell as well, is that child abuse, as covered by the Oklahoma child abuse statute, is not what Congress intended to cover by adopting the federal assault statutes. And one of the reasons we know that is because in a parallel area of law, in the Major Crimes Act in 2006, the Congress added child abuse and neglect to the list of crimes that may be charged against Indian defendants under the Major Crimes Act. And then years later, Congress added any felony under Section 113 to that same enumeration of offenses under the Major Crimes Act. And when they did that, they did not remove the words felony, child neglect, and abuse, because it understood, as I think this court has held, that there is no general federal child abuse or neglect statute. And so by leaving both of those things in there, Congress made clear that they understood felony, child abuse, and neglect and felonies under Section 113, assaulted felonies, to be different, even though 113A7 addresses, at least in part, some assaults against people under 16.
Counsel, what role in this case is the government's position that Shell was wrongly decided have?
It is one of, I think, 4 ways that we could prevail on that first count, but it is an extraordinarily important issue going forward for the reasons that Mr. Gifford, I think, expressed. The government has an interest in protecting Indian children, whether they be assaulted by Indians, in which case it would be chargeable under the Major Crimes Act, or whether assaulted by non-Indians, in which case under our reading, and I think a correct reading of Lewis, they could be charged under 1152 under the General Crimes Act. That said, because Shell specifically exempted child neglect and said that they were not considering that issue, and because 843.5 is plainly divisible, this court could affirm on the basis of the child neglect conviction alone and hold explicitly that that Oklahoma statute 843.5C may be assimilated, but I think that's implied by Shell. We think the broader holding that all of the abuse provisions of 843.5 may be assimilated because.
But you agree, and I maybe I'm missing the point here, but you agree that to even engage with Shell as an unpublished decision and grapple with its holding and reasoning, we would have to agree that it is intervening law for purposes of the timeliness of the post-trial motions, right?
I'm not sure that's true. Certainly, the way that Mr. Gifford has raised this argument is only in the district court's failure to consider those issues. However, Mr. Gifford could have raised the underlying arguments in Shell before this court on direct appeal. And that's why, and frankly, to not have done so might have been ineffective. And so because this issue of whether federal child abuse may be assimilated is critical both in the general area of Indian law and to this case in particular.
To maybe some future version of a component of this case, but it's not directly at issue before us unless we overlook timeliness, right?
I think that's arguable, but at the end of the day, some explanation of whether Mr. Gifford should have raised the Shell issue earlier or should have raised it before this court could be addressed by a holding that the underlying premise of Shell is simply wrongly decided.
Okay, but you said there were 4 ways, and that's one way. So could you briefly summarize the other 3 ways?
Sure. The first is that the district court didn't abuse its discretion in finding that the fourth motion to dismiss or motion for new trial was untimely. It was filed more than 2 years after Ms. Smith's first motion to dismiss, nearly a year after the post-trial motion to dismiss. The prejudice was clear, and for the reasons I think you discussed with Mr. Gifford, this wasn't the reasons for delay were not sufficient to justify. And so the district court arguably did not abuse its discretion in declining to hear an untimely motion. The second is that Shell is wrongly decided. The third is that any Shell error is harmless because 843.5 is divisible, and Shell doesn't apply to, it explicitly recognizes they're not addressing acts of omission like neglectful abuse. And here, Ms. Smith, unlike Mr. Shell, was charged with child neglect as well as child abuse. Okay, that's actually 3 ways. So I think there are 2 prongs in the Shell was wrongly decided, but we will leave it at that. And I think with my 43 seconds, I will just say that to the extent that the district court's decision to even read the letters sent by 3 trial witnesses before sentencing Ms. Smith could possibly exceed the vast discretion we give district courts to consider anything at sentencing. If it exceeded that discretion, it nonetheless did not violate Ms. Smith's rights because the district court explicitly said that it was not going to consider that to the extent
Counsel,
that
did the government represent that these letters were from victims? Should we understand that these are victim statements under 3771, like the understanding of crime victim, or were these letters more in service of information at sentencing, and therefore we would understand them under a different statutory framework?
I think we should understand them under a different statutory thing.
But did the government say they were victims? Did the government tell the district court these are victims?
It's not clear. These were submitted not by, I think, the attorneys, but by the victim witness coordinators who sometimes collect letters and forward them on to the probation office, which then submits them to the court. And so all of that, it's not clear exactly how they were characterized, but certainly the district court didn't understand them to be victim impact letters. And for that reason, any error here is certainly harmless. For all those reasons, we would ask this court to affirm. Thank you.
Thank you, counsel. The case will be submitted. Thank you for your argument this morning, Mr. Gifford. You may be excused. Ms. Alam, we'll give you a half-hour break before we see you again, and we'll move on to the next case. Right, we'll next hear United States versus Gaines, number 255000. Counsel, you may proceed. Mr. Casey.
Justices, and may it please the court, my name is Andrew Casey, and I'm honored to be able to represent Mr. Gaines today. The question before this court is whether the district court improperly allowed Exhibit 4 to be admitted to the record despite Eric Williams not appearing to be confronted and cross-examined, and despite the district court not properly analyzing whether good cause existed for the government to fail to produce Eric Williams as a witness. Because neither of those conditions exist, it was error to admit the exhibit, and without the exhibit, the government failed to meet its burden by preponderance of evidence that Mr. Gaines violated his supervised release. I would ask for the court to reverse the district court judgment with instructions to dismiss. I'll move to the first argument, which is the actual statements themselves and whether the exhibit was improperly admitted under 32.1 BC2. And what I would note is that there are a number of cases from this circuit that I think squarely prevail in favor of the appellant. The first is actually a decision by you, Your Honor, Judge Matheson. It was United States versus Jones. And in that opinion, you and the panel had indicated that we would adopt the balancing test instead of the reliability test. In that case, there was a murder accusation, but a witness had refused to testify after giving a lot of statements to a detective, but there was no subpoena, no attempt to contact the victim to show up at the actual sentencing. And that evidence also contained quite a few different things in it. But that case led to a ruling where a district court had to be reversed and remanded based upon that. I have two cases that I cited.
Mr. Casey, could we back up a little bit? First of all, I take it you're not contesting that the statements at issue in Exhibit 4 would meet the requirements for an excited utterance under Evidence Rule 803. You're not challenging that.
No, but I would also say that it did happen after he was detained, after 911 calls that Mr. Williams did not make, and after some period of time, at least 8 minutes had passed by.
All right. Moving on, we get to Rule 32.1B2C. Does it apply to hearsay statements that are admissible under a hearsay exception?
So it would apply, and confrontation for that adverse witness would still have to be protected, even if the hearsay statement itself was something that could be admissible at a trial. So what I would note is that the old reliability test said that you have to allow the hearsay evidence without cause regarding availability if it was sufficiently reliable, which isn't that different from sentencing. But for here, the balancing test that was adopted by Jones, that had been adopted from the 2002 amendments, makes it very clear that you have to assess the confrontation interest, and then you have to balance that with the good cause shown by the government.
Counsel, that assumes that Rule 32 applies, and my question is, does it apply at all when you have hearsay that would qualify for a hearsay exception? I guess what I'm going for with this question, counsel, is it seems like this court hasn't addressed that specific question, and other courts have. So what should we do about that?
I would indicate, Your Honor, and there's a couple of cases that I've cited that I think can apply to that answer. So I would note that here you still under the balancing test.
Well, why don't you talk about your best authority? Is there a case that supports your position that you think we should follow?
I would ask the court to look at page 23 of my brief. I've got two citations I want the court to consider from the 8th Circuit. First is United States versus Timmons, which is 950 Fed 3rd 1047. And I want the court to consider United States versus Sutton, which is another 8th Circuit case, 916 Fed 3rd 1134. In Timmons, there was a body-worn camera of an alleged victim after a 9/11 hang-up call. And the district court had admitted it as an excited utterance. And the circuit court in the 8th Circuit said that because the victim was in the same state as the proceedings, and the statements weren't corroborated except by a 911 call, that it had to be subject to the balancing test, and the government had failed to prove that the balancing test had protected the statements. Here, the rule in 32.1 is plain that Mr. Gaines has the right to confront an adverse witness, which Eric Williams was at this point, based upon his statements. And under those two cases, I would indicate to you that there's significant authority to say that Rule 32.1 applies on that basic due process component. Does that answer that question?
In your view, does I'm sorry, you please finish your answer to Judge Matheson's question.
I think I finished it. I'm ready for it.
In your view, how did the district court understand this video? What did it? Do you think the court thought it was hearsay that had to come within an exception? I mean, the district court gave a number of different rulings, it seemed, or thoughts about what this was. You know, excited utterance, a present sense impression, effect on the listener, things like that. So what is your understanding of what the district court's ruling is that we should evaluate that either triggers Rule 32 or the balancing obligations there, or doesn't?
I'm looking at the record from volume 3, pages 42 to 44, which is the discussion with the district court, where it analyzes just the reliability of the hearsay statements. That to me left the impression that the district court evaluated this as one would have the reliability test that was under Kell before we had United States versus Jones.
Well, that actually makes me wonder about something else, and it's a much more antecedent question about sort of preservation here, which the government hasn't raised, and maybe for good reason. But you know, Jones was available to you at the time that you were making this objection, and you cited to the district court, you know, we object under Rule 32 and Morrissey and 10th Circuit law, but you didn't focus the district court on Jones, and Jones is really the case that understood what the advisory committee notes were all about, that this was a shift from reliability to this balancing test. So without mentioning Jones to the district court, why should we think the district court was on notice about what its obligations were under Jones?
Because Rule 32.1B2C was specifically cited, and that was the rule specifically recognized in Jones. And I don't think that raising Jones at that moment would alleviate the fact that the statutory authority from and how the 2002 amendments happened was not raised and presented to the court. And in that, then the discussion of what in the interest of justice requires for whether or not that happens. The rest of the analysis that is there is all related to that part of it. And so that's what leaves me with the impression that the error is preserved as far as that goes. I would also note
let me ask you a quick question. What would be the outcome of your case if the district court had done everything exactly like he did, but at the end of the colloquy, when he was getting ready to overrule your objection, he said, I have balanced all of these factors under Rule 32.1 and deny your motion?
I think that the case, I'm sorry.
Go ahead, no.
The case law is very clear that simply mentioning the analysis, simply mentioning that you went through balancing is not enough to actually conduct balancing. And here the record shows significant information to you about how there was discussions about how the witness was uncooperative, but there was nothing to suggest that he was under subpoena, that the subpoena would be futile, that there was anything that was done as far as it goes. And so I would say that the judgment was still incorrect, even if he mentioned the balancing test at the end.
I guess the problem I'm having is what happened at the court. And I don't know if you were trial counsel or not. I'm not faulting anyone at trial at the district court because it's fast and furious, but it seems like what happened is it was like, I object under Rule 32.1 because I want to confront the witness. I want to cross-examine them. There are a lot of questions I would like to ask, period. But nobody suggested to the district court that the method he used to analyze this was wrong. Maybe the distinct point that you wanted to cross-examine and confront the witness was made, but nobody suggested that the district court had not engaged in balancing at that point.
I would indicate, Your Honor, I think that one of the statements that you said is precisely my viewpoint from having been in the room, which is that we're working through, and Your Honor is very fast, he's very direct, and I'm answering questions and we are moving on very quickly before we get the overruled to the objections. And so I had tried to note that I had issues with the accuracy of the statements that I wanted to cross-examine on, that Rule 32.1 had to be preserved. And I think even the way that that had happened was there was an attempt to admit another exhibit. I had noted that I was going to make that objection. We kind of slowed down, and then I made the objection, and it went very quickly after. And so that I think that the error was preserved as far as 32.1 goes, except that he had indicated that he thinks that the district court thought justice so required the overrule. And on that, I don't think that there's enough information to confirm that. And I do believe that that was error too. Your Honor, I've noted a couple of different
could
things.
I just, sorry to interrupt, but let's say we agree with you and Exhibit 4 is out. Apart from Exhibit 4, why didn't the evidence show by a preponderance, and I'm talking about the remaining evidence, that Mr. Gaines possessed a firearm and shot Mr. Williams?
Thank you, Your Honor. I think that Officer Awad's testimony and even the exhibits themselves all leave significant concerns about whether they've met the burden under preponderance of evidence. For instance, Officer Awad, whenever he discusses the exhibits where there was a claim to see something in Mr. Gaines's hand, had indicated he has no idea what that object is, and there was nothing further as far as it goes. There was a holster inside a car, and there was no indication that that holster would fit the particular weapon in the case. There are iron sights, but I think that I have a unique problem with the iron sights because, one, iron sights on a handgun are just not something you can take off on a quick measure. And there's two of them in two separate rooms. And I think that the cross-examination of Officer Awad said, this is for an AR. And most certainly there's no indication that anybody was shot with an AR. So the iron sights don't confirm anything as well. And then there's just an empty box that has an ammunition label on it, but there's no other portions of its part that are there. Mixed with the statements from Mr. Gaines denying it, there's just nothing to corroborate it besides what's in Exhibit 4, and
So-
that's.
So
Well,
let me tell me if this. I'm sorry. Do you want to go ahead, Judge Metz?
Just to clarify, though, is your answer the same if you break it into possession of a firearm on the one hand and the shooting on the other?
I
In other
believe
words,
so.
your argument seemed to go more to the shooting part than whether there was enough to show possession of
That's
a
true,
firearm.
That's true, but I have one other good argument that also goes to possession, and I think those earlier ones do speak to possession. I would note for the court that with the testimony from Officer Awad talking about Mr. Gaines being intoxicated, and with no one corroborating any idea that a gun was handed off or that Mr. Gaines had run away and hid it, and with two things from law enforcement, the quick reaction to get to the scene, and then the thorough search of the area, none of which produced a firearm at all, there's just no evidence that corroborates that they had a firearm at that time. It's mere speculation based on items in a truck, and they have no evidence to say that he went near the truck at that time. And then iron sights and that have no relevance to fitting a particular firearm. And so, the old adage, if there's smoke, there's fire, but we don't have smoke as far as this goes. What we just have are things that wouldn't surpass and won't survive preponderance of evidence. And that's also why I think that this is not harmless error as well, simply because if Exhibit 4 is out, they just haven't met the burden to show that he possessed a gun or that he shot somebody with that. And I think that the evidence is that, and I think that's ultimately why cross-examination of Mr. Williams was so important, because it got to the ability to test his accuracy, test his viewpoint, bring up things like his criminal history, his level of intoxication, whether he's lying about Mr. Gaines, whether he's protecting somebody else. All of these would be fair game.
Judge Matheson,
Judge Carson, go ahead.
would you indulge me one quick question?
Oh, please, please. I'm
Okay.
anxious to hear it.
You'll probably regret it. So I may be remembering this wrong, but I seem to remember testimony in the record from the officer that he understood from the other officers that the defendant admitted or that the victim said the defendant shot him. Do you recall that testimony in the record?
There was the way that I remember it was when he was being explained the call out, there was a discussion that Williams was shot as far as what was relayed to him to show up to the scene, and that they had a suspect. But I don't remember getting to a point where there was an actual statement that this is the shooter. And then, of course, they had Mr. Williams detained at the scene. Whenever the body worn camera officer, which was an officer.
That's fine. I don't want to drag. I don't want to make you drag on there. I just had a discreet question, and it sounds like I'm just going to have to get back in there and take a look. Thanks for trying to answer that, though.
Thank you, Your Honor.
Thank you, counsel. Counsel, I think your time is up, and we're going to move over to Mr. Anderson.
It flies by, Your Honor. Thank you all so much.
Thank you. Mr. Anderson.
May it please the court, Elliot Anderson for the United States. I'd like to begin with answering Judge Matheson's question, and to that I will say that I'm not aware that the 10th Circuit has ever held that Rule 32.1 B2C can exclude otherwise admissible hearsay from a revocation hearing. In Jones itself, the hearsay would not otherwise have been admissible. The victim or the witness had spoken with the detective and then was unavailable, and the detective was going to take the stand and repeat what had been told to him. That would not have been admissible at trial. The other cases that the appellant relies on largely involve cooperative witnesses that the government did not work hard enough to get to trial. They largely do not involve otherwise admissible hearsay. And the 10th Circuit certainly has not. The second reason I think this is the correct answer is that it would be error.
Counsel, I'm not sure. Let me throw out that it seems like there are other circuits that have addressed this issue, but I think there's a circuit split. Are you seeing a circuit split on that issue?
I see cases coming out either way. I don't know that I've seen a lot of cases directly phrasing the question in those terms and answering it. I think the better answer, though, is that Rule 32.1 cannot be read to make the standard of admissibility more restrictive at a revocation hearing than it would be at trial. It would be error to read Rule 32.1 under Jones and under all of this court's precedent on revocation, which all acknowledge that a defendant at a revocation hearing, it's not a criminal prosecution. They do not have the full panoply of trial rights. But then to read Rule 32.1 to exclude an excited utterance that would come in at trial, regardless of the declarant's availability, that is a misreading of the rule. Third,
Well, counsel, I don't see anything in the rule that speaks to this at all. It says the defendant's entitled to an opportunity to appear, present evidence, and question any adverse witness. Doesn't say anything about hearsay, exceptions to hearsay. Just says that the defendant's entitled to do that. So I don't see, based on the text of the rule, an answer to this question about if we have an excited utterance here, does it really matter? He still has an interest in cross-examining Mr. Williams.
the rule goes on to say, Your Honor, if I'm recalling correctly, unless the judge determines that the interests of justice don't warrant cross-examination.
Oh, well, that gets us to the balancing test, right?
The balancing test that appears in the advisory committee note. Yes,
Well,
sir.
doesn't the advisory committee note about the balancing test relate to that portion of the rule?
It does, Your Honor.
Okay, and if the rule does apply, we said in Jones, as Mr. Casey pointed out, that just mentioning the rule isn't enough. Just mentioning balancing isn't enough. So how did the district court here actually apply the balancing test?
Three ways, Your Honor. First, the court examined the reliability of the evidence, which Jones says is very important. And here the evidence was extremely reliable. Mr. Williams in Exhibit 4 is excited under the stress of the moment and had been shot somewhere between 5 and 10 minutes earlier. Second, the court quizzed defense counsel on why exactly did he need to cross-examine this witness. The district court directly engaged on that point, and defense counsel's only answer was the reliability of the statements. He did not contest that Mr. Williams said what he said. Now, as to the reliability of those statements, those are baked into the circumstantial guarantees of trustworthiness and the hearsay exception. The third reason, and this goes to Judge Rossman's question, is that defense counsel conceded at the hearing that Mr. Williams was uncooperative and unavailable for testimony. So Officer Awad testified, I attempted to contact him repeatedly after the incident. He was uncooperative. Defense counsel not only didn't object to that, defense counsel at volume 3, page 39, says on the record that he understands Mr. Williams is uncooperative. It would have been a meaningless exercise, and it would be a meaningless exercise to remand just so that the judge could say the magic words, I have heard both sides agree that the witness is uncooperative, and now I understand that the witness is uncooperative. That part was implicit in the holding.
Oh, wait, a lot of witnesses are uncooperative, but you subpoena them in. Did the government subpoena Mr. Williams?
I could not find a case, Your Honor, where the government has been required to subpoena.
Well, I didn't ask that question. I asked the question,
to my
did
knowledge, they did not.
him? All right.
To my knowledge, they did not. And the cases that were cited in both briefs that faulted the government for not subpoenaing a witness all involved cases where the witness had cooperated. So in Dentgraf, in Timmons, in Sutton, in Coleman, the witness had spent hours talking to law enforcement, and then law enforcement didn't subpoena them. In contrast, in Williams, they made multiple attempts to contact the witness and could not, and the court excused the witness's presence. In Carter, the witness obviously would have refused to testify, and in Martin, the witness refused. The district court did not explicitly address the availability of the witness, but the Eighth Circuit said there's enough evidence in the record for us just to do the balancing ourselves. The government clearly had a good reason for not presenting a witness who would not and never had cooperated. That is the distinction in the cases as I see it, Your Honor.
But the district court here never factored in its decision-making the unavailability of this witness, right?
There would be no reason to, Your Honor, because no one.
Well, that's the
argued that
separate.
it was.
There may not have been a reason to, but just descriptively, the district court didn't address that piece of the analysis. Is that
fair? The district court did not repeat what both counsel had said. Yes, on that point. As to the harmlessness of the error, the district court, before it reached its holding, deliberately scaffolded the evidence up. It said, some of this makes me start to think. Some of this makes me begin to wonder. The evidence is starting to mount. And the court said, and I find it pretty overwhelming. And the court said that before it even discussed Exhibit 4. So setting Exhibit 4 aside, there was ample evidence for a reasonable trier of fact to find that more likely than not, Craig Gaines shot Eric Williams.
Well, counsel, what is the harmless error standard that the government contends applies here? We've not decided that question about whether errors under this rule are considered to be constitutional or non-constitutional harmless errors. So what is your position on that?
I think the better answer, Your Honor, is that it's non-constitutional because the cases are in agreement that at a revocation hearing, the confrontation right isn't a pure confrontation clause right. It comes from the Fifth Amendment, not the Sixth. So I think it would be over elevating the standard here to hold that this is a constitutional error when Mr. Gaines is not asserting a constitutional right. He's asserting a right under Rule 32.1 and just general.
Is the balancing test that the rule requires coextensive with Morrissey?
I would say no, Your Honor, because this is not this isn't a full. The courts that have examined this, I believe I cited a Fourth Circuit case and a Seventh Circuit case, point out that the confrontation right at a revocation hearing is not on all fours with Morrissey. It's something less than that. I believe that's the better holding here, because again, we should be, it should be easier to get reliable hearsay in at a revocation hearing than it would be at trial. And here the district court said this would be admissible at trial more likely than not, and he saw no reason not to admit it there. But setting that aside, so there's not a substantial likelihood that Exhibit 4 had a prejudicial outcome on the effect, because what the court saw is in Exhibit 1, Craig Gaines standing at Eric Williams' door with an object in his hand. It is small and metallic. Is it undeniably a gun based on that video? No. But it is undeniably not many other things. It's undeniably not a box of Girl Scout cookies or a pan of brownies or even a slingshot. It is the size and shape of something that's consistent with the other points in the narrative, because witnesses told police they saw Gaines and Williams arguing in the parking lot, and one of them pulled a gun on the other one. And in Exhibit 2, we see Mr. Gaines raise his arm toward Mr. Williams, that arm that is holding something that's not a box of cookies. And Mr. Williams spreads his own arms and says, "Are you going to shoot me, cuz?" And then at that point in the analysis, the district court paused and noted the other evidence: the small holster in Gaines's truck, the firearm accessories in his apartment, the small caliber ammunition box outside his apartment, the empty shell casings in the parking lot where he'd been arguing with Williams. And the judge says, and lo and behold, Eric Williams shows up getting shot. At that point in the evidence, even without Exhibit 4, it would not be arbitrary, capricious, or whimsical for a fact finder to conclude that the man who's holding a gun
That's like a different standard, right? I mean, we're not, if you're arguing now under harmlessness, could you be just as precise as possible about two things? The first is you maintain that it's the non-constitutional harmlessness standard, and I think you've effectively explained why that is so. What is precisely the question that we are addressing under that standard in this case?
Whether, Your Honor, whether we decide that it's non-constitutional or constitutional, the government can prove beyond a reasonable doubt that the error is harmless, because we only need enough facts for a reasonable trier of fact to conclude, more likely than not, Mr. Gaines held a gun, pointed it at Mr. Williams, and shot him with it. And there is ample evidence in the record before we get to Exhibit 4. And that, I think, is evidenced by the court's own analysis, where he walks through it deliberately and says, Exhibit 1, Exhibit 2, the physical evidence, the witness statements. It's not just coincidence, lo and behold, that Mr. Williams got shot. He got shot by the person who was pointing something at him, something that is about the same size and shape as a gun.
Counsel, wasn't
But
there evidence that there were other people there? It wasn't just Mr. Williams and Mr. Gaines when this incident occurred, correct?
Yes, Your Honor, there were multiple people who witnessed parts of the incident and reported it to police, but there were no witness statements and no physical evidence implicating any third party in the shooting. There's nothing in the record at all to cast suspicion away from Mr. Gaines.
But we're discussing the sufficiency of the evidence that supports the ultimate decision to revoke. And I thought our question on harmlessness was directed to whether the court would have admitted the exhibit under the Rule 32 balancing test on the record before it. Isn't that a different question?
I apologize for misunderstanding your question. When I spoke to harmlessness, what I meant is that the admission of Exhibit 4 is not what tipped the scales, so that even if it was error for the court to admit it, the court would have reached the same decision. A reasonable fact finder would have been justified in reaching the same decision without Exhibit 4, just based on everything that came in before that. Now, as to the harmlessness,
I mean, this is the formulation in Jones. And formulation in Jones is we have grave doubt as to whether the court would have admitted the testimony under the Rule 32 balancing test on the record before it. And if that's the way, the formulation of harmlessness in Jones, and if we apply that here, and I think that calls for us to look at a different set of data points.
I understand your question now. Let me try to rephrase. If someone had objected at trial and said, Your Honor, you're applying the wrong test, or you haven't done all the balancing. You've talked about reliability and interest in cross-examination, but Judge, you didn't say anything about the availability of the witness. I don't think there's serious doubt that the judge would have said, something to the effect of, everyone agrees the witness is uncooperative and wouldn't testify against Mr. Gaines. It would have been one additional sentence that wouldn't have changed the outcome. So here, I don't think we have that grave doubt. It's just, it's if there's an error at all, it wasn't raised below, but factually, the point was uncontested. If there are no further questions, we request that this court affirm. Thank you.
Thank you, counsel. I believe we're out of time for Mr. Casey, so we will consider the case submitted, and we thank you for your arguments this morning. Thanks for cooperating with the Zoom. You weren't expecting to be on Zoom, and neither were we, but it seems to be working out okay, so thanks for that. We'll excuse both counsel and move on to the next case. All right, our final case this morning is United States versus Williams, number 255011. Ms. Alam, we'll start with you.
Thank you, Your Honors. Lena Alam for the United States. In this case, the district court made two fundamental errors that require reversal. First, it misapprehended this court's precedent, allowing magistrates to base their determinations of probable cause on reasonable, common sense inferences from the evidence contained in a search warrant affidavit. Second, it misread Gonzalez, leading it to ignore critical evidence that supported the minimally sufficient nexus that would have allowed application of the good faith exception. I'll address first the failure to allow the magistrate's inferences. The district court cited Bigelow, but failed to address the four factors that Bigelow, the four non-exhaustive factors that Bigelow identifies that may be used to assess whether nexus exists in a given case. First,
before you go into that, I want to make sure we're talking about what the legal standard is here, right? We're talking about a substantial nexus. Is that fair? That's what Bigelow says.
Well, it depends on which issue we're talking about.
We're talking about the first issue. We're talking about your first argument for reversible error.
Yes.
Not good faith.
Yes, whether there's a substantial basis to find a nexus or a reasonable probability that's connecting the criminal activity with the place to be searched.
Okay.
And so under that first element, the Bigelow and Mora and other cases counsel that the magistrate judge should consider the type of crime at issue, the extent, if any, of the suspect's opportunity for concealment, the nature of the evidence sought, and any reasonable inferences as to where a criminal might or would keep the evidence being sought. So here, the crux of the magistrate judge's nexus finding, the connection between Mr. Williams' criminal activity and his home was his Jeep, which on September 26th, one of the local police officers who had arrested Mr. Williams for obstruction noticed that Jeep contained an emergency light bar, a CB radio, and a public address system. Those officers also discovered that the glove compartment of his Jeep contained two FBI badges, fake FBI badges, and handcuffs. All of these facts were in paragraphs 9 and 10 of the search warrant affidavit. Paragraph 10 also noted that the badges were seized and booked into evidence. So from those facts, a magistrate could draw a reasonable common sense inference that the emergency light bar, the PA system, the CB radio, and the handcuffs were not seized or booked into evidence. In fact, as it happened, when the search was later run, those items remained in the car or in the Jeep. The next critical fact in the affidavit was that after the local police arrested him for obstruction, the FBI got involved and began an investigation into 18 USC 912, impersonating a federal officer. Their interests in the investigation were very different than the local police who charged him with obstruction. So in doing so, they noted that other items suggesting that Mr. Williams was impersonating a federal officer had been noticed in the car, and they sought to search his home for those items. But before they did that, they conducted surveillance. And in conducting surveillance at that house that the Bixby police report had indicated was his home address, they saw the very same Jeep with the very same license plate.
Counsel, can I I have a sort of first principle question. What is the criminal activity that we're looking to connect to the home? Is it using what the district court said, which was using the fake badge in the pickup line? Is that it, or is it something that developed later?
I think you've identified one of the problems with the district court's analysis, which is that the district court was improperly focused on that one moment on the 26th of September, whereas the investigation, and typically a federal investigation, is broader than that. Now, the crime that they were investigating Mr. Williams for was impersonation of a federal officer. And as the district court observed, that occurred certainly on the 26th of September, but the scope of the investigation encompassed more than that. Whether Mr. Williams had continued to or had previously impersonated a police officer. Some of the other items in his car or in his Jeep suggested that he might have engaged in other conduct impersonating a police officer, for instance, traffic stops or anything like that. So the fact that he definitely or engaged in conduct that might have satisfied the statute on the 26th did not prevent the FBI into investigating his conduct as a whole. So based on that, the FBI agents, after noticing the same Jeep that had contained those items of evidence on the 26th, parked in front of Mr. Williams' house up against the garage on the 1st of October, sought a federal search warrant and were granted a federal search warrant. And that
but the search warrant was for the house, right?
For the house and any vehicles on the curtilage. So that would have included the Jeep.
So in order to endorse your argument that there was a reasonable inference the magistrate could have made that the district court erred in rejecting, there has to be something in the affidavit that would have told the magistrate why the house was likely to have the items that were in the car. There has to be some factual basis from which that inference could be made. And I don't see it. So maybe you can help me see it.
Okay. I think what Bigelow stands for is that the facts, the inference that the things might be in the house is an inference the magistrate can draw from the facts that are presented. The facts here that are presented are that Mr. Williams was confronted after presenting fake FBI credentials on the 26th, had other items that were related to impersonating an officer in his Jeep. And later that same Jeep was parked at his house. A magistrate could make a reasonable common sense inference that a smart person, having been arrested after showing an FBI agent, a fake FBI badge, might have removed other evidence that he was engaging
but the officer, he had that in the car when the officers arrested him and they didn't seize it. And I don't think that you argued concealment to the district court. Did you?
We argued that the magistrate could draw inferences that would have that directly addressed the items seen in the car parked at the house, and the house itself. The word concealment wasn't said, but certainly the Bigelow factors and the types of inferences that a magistrate may draw were absolutely argued to the district court. And in fact, the district court specifically rejected that argument, saying if the Fourth Amendment only required a list of items to be seized, leaving a judge to fill in the necessary connections or inferences to be drawn from the facts to support the search, the Fourth Amendment's probable cause requirement would be rendered meaningless. That's simply inconsistent with Bigelow. Here,
so is it your position that the magistrate judge was supposed to draw the inference that the listed items were of the type that would be found in a house?
Not in every case, but in this case, under these circumstances, the magistrate could reasonably have inferred, after having been arrested for impersonating a police officer, having been arrested for obstruction after impersonating an FBI agent, that a defendant who then had his car at his house might have had the incentive to take other evidence out of that Jeep. And so the magistrate judge could reasonably have inferred that the items that were seen in his Jeep on the 26th had been moved into his house or were still in his Jeep on the curtilage on October 1st, when the FBI agents observed it and when the warrant was obtained. That was a reasonable inferential change.
Could I just jump in and ask you whether you would agree that in a given case, and maybe it's this case, that there's a fine line between the magistrate drawing a reasonable inference on the one hand and filling in a gap in the affidavit that the affiant really should have filled in themselves. Isn't that really the crux of the first issue, is determining whether this inference you're talking about truly is a reasonable one, or whether it's really a matter of, can the magistrate step in and fix a deficient affidavit?
Really, this is precisely the type of connection that Bigelow speaks of, right? In order to find nexus between evidence that a defendant may have been involved in criminal activity and the defendant's house, there must be some additional evidence linking the criminal activity and the house. And Bigelow makes very clear that that additional evidence may be based on an affiant saying, I think this stuff is here because criminals of this type often store these things in their house. I don't think that would have been an appropriate statement here, because there's no criminal, people who impersonate FBI agents often keep their things in their house. There was no such statement, and that inference might not be a general one. It's not like a drug crime or a gun crime where agents have enough experience with them to make that inferential statement. But certainly based on the facts of this case, and that's precisely what Bigelow speaks to, this magistrate could have drawn this inference, and Bigelow specifically permits an inference like this one drawn by a magistrate judge to provide the additional evidence of nexus required for probable cause. And significantly, the amount of deference due to the magistrate's determination here is something that the district court did not seem to grant. And so, and part of that is because the district court was improperly focused on whether the government could prove the crime just based on the initial incident itself, whether they needed to go into the house to get additional inference.
Could you just clarify one thing? At one point in your briefing, it says the FBI sought to search the home for evidence like the items the local police had seen but not seized. So were they looking for items like the ones in the Jeep, or were they looking for items that were in the Jeep?
The items listed in attachment B match up largely with the items that were seen in the Jeep, but also other items like that. And that's why I use the word like in that context. So other FBI gear, like body armor, things like that, but also it specifically lists the handcuffs, it specifically lists an emergency light bar, and police radios, which would have
Okay,
been the
that,
basis.
thank you for the clarification.
If I may, I'd like to reserve the remainder of my time.
Thank you, counsel. Ms. Barton?
May it please the court, Bryn Barton on behalf of Mr. Williams, the appellee. I'd like to start talking about this issue of waiver. It briefly came up in your questioning of the government. The government says that it made the same argument and that it did talk about this potential opportunity for concealment because it talked about the Jeep. But if you go through both the written response to the motion to suppress and the extensive hearing transcript, it's not just that the phrase opportunity for concealment did not come up. It has more to do with the fact that the government was not focused on the Jeep or on specifically on the items within the Jeep in its argument before the district court. If you go through that transcript, it only one time does it address the items within the Jeep outside of the factual basis. And it says on page 142 of the appendix that the items seen in the Jeep at the elementary school, that the light bar and the handcuffs obviously suggest an ongoing crime. This was part of the government's argument in front of the district court that the reason that we are connecting this crime to this home is the nature of the crime.
And isn't there a reasonable inference that these items that were noticed by local law enforcement in the Jeep are the types of items that someone who impersonates a federal officer might use?
It does not say that within the affidavit. And
no, I understand that. I'm asking you if it supports a reasonable inference. They did lay out the facts. They did state that those things were in the Jeep and not seized by local law enforcement. I mean, couldn't the magistrate judge draw a reasonable inference that those were the types of items that someone impersonating an officer might possess?
I think he could make, or the district judge could make an inference like that. The problem here is that's not the only inference that is needed to be made. And just to make a quick correction, I realize that there's this inference that the items were still in the Jeep when they were seen, or they were still in the Jeep when whoever picked up the Jeep from the tow yard brought it back to this residence. But the affidavit does not say what happened to any of these other items. It says that it grabbed and booked the 2 badges, and it mentions the handcuffs in that statement, but it does not talk about any of these other items. We also know that Mr. Williams was arrested that day. We don't know when he was released from custody. We don't know if this vehicle was registered in his name. We don't know if he picked it up and drove it back to that house. So even if that's one reasonable inference that the magistrate could make, it's this long string of inferences that is our problem. Even get to the point that the inference is maybe he moved these items that were in the Jeep into his home, we have to come way too far to even get to that inference through all these other inferences.
Counsel, I'm asking a clarification question again. There's reference in your briefing to the Jeep being seized on September 26. Have I got that right?
Yes.
Okay, and there's also reference to an inventory search. So what happened to the items in the Jeep on September 26? Were they just left there, and when the Jeep left the authorities, they were still there? Do we know that? What exactly were you trying to say in your brief about that?
What I was trying to say, I think, is reflected very well in your question. We don't know what happened to those items. The affidavit does not say if those items were removed, if they were not removed. And all we have is this one passing reference where an officer says that he believes that he saw these items. And then we know there was an inventory search, and in that search, they grabbed the badges. But we don't know anything else about what happened to these items following September 26th or even following the tow.
So does that mean, in your view, that the absence of that makes any inference that they were moved from the Jeep to the house unreasonable?
Yes, I do believe it's so. And I think that would be unreasonable on its own because the affidavit doesn't say anything about that. But in light of the fact that there are all these other inferences that need to be made, it certainly makes it unreasonable.
Can I ask you a question about how we should be thinking about these different but kind of related legal standards here? For the first issue, the requirement is it's for a substantial nexus, and for good faith, it's a minimally sufficient nexus. And I take it from your argument there's no nexus no matter what you call it. But could you address how we should be thinking about the minimally sufficient nexus for the good faith, and sort of what is your best argument for why the good faith exception doesn't apply here?
I think the district court handled this very well in its opinion and order, and that is that, as you stated, there is no nexus. That is our argument. But it also is any reasonable officer in this situation who would take this affidavit, would look and read that events happened on September 26th, and then it would have 11 pages about computer crimes, and then it tells you what to seize. And there are little bits and details that the government is trying to pick and fit in to try to make these inferences work. But just reading the affidavit, I think in a common sense way, and as you would, it says this is not supposed to be legal professionals who may understand all of these different factors and things we can consider, but they are supposed to understand reasonably the basics of the law. And if you're reading this affidavit, I think a reasonable officer would question, why are we searching the home of someone where he held up a badge one time in front of an elementary school? And that's why I think good faith doesn't apply.
Well, because the crime wasn't holding up a badge, the crime's impersonating a federal officer. And so when you're looking for evidence of that crime, it is more than flashing a badge, isn't it? There can be lots of other indicia that somebody is doing that.
Your Honor, I think in this situation, not necessarily, because just owning a badge or just owning, let's even get into the light bars, that does not mean that you're impersonating a federal officer. There has to be
You wouldn't agree that those items could be evidence of someone. If he said, I wasn't impersonating an officer, and you trot out all of these additional items, that wouldn't be indicia of him maybe impersonating an officer?
Okay, I understand your question a little better. I do think it would be reasonable to say that. However, that still does not get us into his home. And the government's argument, at least on appeal, comes down to these specific items could have been moved from the car into the home. But there's this greater scheme of there's no connection in the affidavit that is actually getting us into the home. And these items were seen in the vehicle. We don't know what happened to them. And then the vehicle is seen in the driveway, but there is no connection to Mr. Williams' home.
What do you think about, on the good faith exception, the argument that the government's made that basically tying him and the Jeep to that home was enough, that on your precedent that there wasn't that even that connection?
Because I think the Jeep itself is not one of these items of impersonation. It is the items within the Jeep that we are concerned about. And the government has not, or the affidavit did not connect the items to the home. And you can make these inferences about it was in the Jeep at that time, but as Judge Russell found in his opinion, based on the affidavit, the inference is that he kept these items in his vehicle, not in his home.
Did the affiant say anything about how, in his experience, when people who impersonate federal officers keep this kind of stuff around in their homes? I mean, it was in their experience. Is there anything like that would make that connection based on the affiant's experience?
There is nothing like that. And when he goes through his experience, he doesn't list any particular experience in false personation crimes or false impersonation crimes. His experience is mostly in, I believe it was drug trafficking, street gang type situations. And he never connects why his opinion and experience would provide probable cause that there might be items like this in the home, and he never says that.
If that had been in the affidavit, would it have made a dispositive difference here?
I don't know if it would be dispositive. I think it would be a very important factor. I think there would still need to be additional evidence because this is not a crime like drug trafficking. I think there have been some pretty specific carve-outs, and this court has called them special class of crimes that kind of inherently, if there's probable cause to believe that this crime has been committed, then there's probable cause to get into the home and believe there's evidence of that crime in the home. This is not within one of those special classes, and the government has presented no case law or argument other than in front of the district court that that is why there is a nexus in this case.
Let me ask you this. On the Exhibit B, the list of things to be seized, there are things like jackets, clothing, belts, firearms. And would you agree with me that the magistrate judge could have drawn an inference that those are the type of things that might be found in someone's home?
No, I don't believe so, because I think this is not the type of crime that gets us to that point. The fact that he allegedly had this bag or these badges and the items in his car does not inherently say that he has these items in his home.
Well, certainly. I mean, there's no. I mean, we don't know if he has them or not. But those I mean, those are all probative of this crime if he does have them, don't you think? If he has police paraphernalia, jackets, shirts, caps, those types of things in his house?
Not necessarily, Your Honor. I think because this was, at least the way it was described in the affidavit, and what we have is one instance in which he held up this badge and they saw their items in his car, but the government's pursuit of this, well, what if he's pulling people over?
I think you're missing my question. So I guess what I'm asking is if there were a prosecution for him impersonating an officer by flashing his badge and the government wanted to trot out additional evidence and they said, and he had an FBI jacket and an FBI t-shirt and an FBI cap in his house, and he had an FBI issue belt, and he had, a firearm resembling those that FBI agents carry, would those items be probative of the crime that he committed?
I think they could be, but I also think the fact that there may be items that are probative of that doesn't mean that the government gets to go search his home without.
Not asking you to admit that. I'm not asking for any ultimate admissions here. I'm just trying to figure out what inferences might be reasonable. And so my next question on that front would be, I mean, if we were looking for t-shirts, caps, jackets, belts, guns, I mean, is it unreasonable for a magistrate judge to infer that those might be the types of items that someone would keep in their house?
Sure. And if I may,
I'm not saying that she made that or that the magistrate judge made that inference. I'm just probing it.
And I would like to now connect this to the case Mora, because I think in that case, we had probable cause to believe that there was alien smuggling. And then they came back to the home, and overall that affidavit failed because they did not connect the probable cause for the alien smuggling to the home. And this
in fairness, though, there was another issue in that case, and that is that they had, without a warrant, gone into the home and identified certain things that were included in the affidavit, right? Like a gun safe.
Yes, but I think when
they would not, and I believe that case that suggested that they wouldn't have been able to get the affidavit without the information that they obtained during the warrantless search.
If I remember correctly, I believe they did go through that analysis, but then when they got to the probable cause, they said, even if we pretended like that information wasn't in there and we only looked at this other information, we still don't find probable cause and we still don't find the good faith exception applies. And the reason that I brought this case up is because in that case, the court was not concerned with, is it conceivable that evidence of alien smuggling would be in this home? Is it imaginable that evidence of alien smuggling would be in this home? The court said the affidavit did not provide sufficient facts and evidence for a magistrate to reach that conclusion. And I think that's exactly what we have here. This is not, is it conceivable in any world that we can imagine that these items might be in his home? It's, does the affidavit that underlines this warrant give us sufficient facts and evidence to do this? And it doesn't in this case. I see my time is up, so unless there are any other questions, I would just ask this court to affirm the district court's ruling.
Thank you, counsel. I believe we have some rebuttal time. You're on mute again, I think.
I was waiting for the timer to reset.
Oh, okay. Sorry.
With my, I think, minute and 23 seconds, I'd like to make 3 points. First, there was a basis for the magistrate to infer that those items remained in the Jeep. That is, that in addition to the actual text of the affidavit contained attachment B, specifically listing the items to be searched for, including the items that had been seen in the Jeep. So there was a basis for that, the magistrate to make that inference. Second, I'd like to talk about the right case to evaluate the good faith exception in this case. It is not Mora, it is Cotto. The critical difference between Mora and Cotto is that in Mora, the vehicle driven by the defendant was found behind a Walmart, and in Cotto, the defendant's vehicle was found parked in front of the house to be searched. In Cotto, it wasn't even his house, it was his brother-in-law's house. But the fact that the car was found there after he had had opportunity to conceal items, as opposed to Mora, where the police beat the defendant back to his house. So in Cotto, as here, there was an opportunity for the defendant to move things from the car parked in front of the house to the house, and that provided a basis to support the good faith exception in Cotto and provides that same basis here.
Does it matter that in Cotto, the affidavit was approved by a DA?
It does not, because as explained in my brief, good faith is an objective standard, and the approval by the DA was irrelevant to the officer's the objective good faith of an officer executing a search. I'd like to close, if I can, by noting that Bigelow specifically observes that the strong Fourth Amendment preference for a warrant compels the court to resolve even doubtful or marginal cases by deferring to the magistrate's determination of probable cause. Here, the district court failed to do that. We are here to ask this court to observe that preference and to defer to this magistrate's determination of probable cause. We would ask that you reverse the district court. Thank you.
Thank you, counsel. Further questions? Hearing none, I think our time has run out, and we will consider this case submitted. Counsel are excused, and this court will stand in recess. Thank you.